The hearing will come to order, and good morning to all of you. I thank you for coming. Our hearing today will take a very good look at so-called social audits by companies whose supply chains originate in the People's Republic of China to cover up the existence of forced labor in those supply chains. Back in the early 2000s, I read a book called IBM and the Holocaust, the strategic alliance between Nazi Germany and America's most powerful corporation. I recall how shocked I was, it was a very heavily footnoted book, how shocked I was at the time that it revealed about an American corporation's complicity in aiding and abetting the Nazi regime, especially in tracking down Jews for the concentration camps. Matter of fact, in the opening, the writer talks about how, do you ever wonder why the Gestapo always had such good lists of Jews? Well, they got it from IBM. Well, they placed then greed over concern for humanity and turned a willing blind eye to the implications of their work. Nor was IBM alone in this. Books have been written about the ties of the White Snow law firm Sullivan and Cromwell had with the Nazis, for example, but I took some comfort in knowing that that was in the past. Surely, if there was evidence today of an evil regime's abuse of human rights, for example, the mass-scale detention of whites, of despised ethnic and religious minority in concentration camps, forcing them to toil as practical slaves to produce goods for exports, surely American corporations would shudder and shun any complicity with that. Fast forward today, however, and that is precisely what we see. Corporate complicity in the grossest of human rights violations. Our hearing revealed, for example, how and this was recently, Thermo Fisher Scientific, whose DNA markers have been used by police in Tibet and Xinjiang Autonomous Region to compile databases of the DNA of millions of Tibetans and Uyghurs, has also been implicated in the forced harvesting of human organs. While Thermo Fisher Scientific may be the corporation whose behavior most closely mimics that of IBM before the beginning of the Second World War, our hearing today focuses on those manufacturers, suppliers, importers, and retailers whose supply chains in China are tainted by reliance upon forced labor to achieve the lowest prices, yet who seek to rely on social auditing companies to obscure and whitewash that reliance. We have known about corruption in the audit industry for a long time. Back in July of 2012, I chaired a hearing, and matter of fact, Thea was there representing the AFL-CIO on this very issue. We also heard at that hearing from Li Xiang, the founder of China Labor Watch, who testified as to the audits. He said, not only are the audits conducted in China ineffective, but he said that, quote, they are actually corrupt. He went on through many examples of how auditors for corporations such as Apple ignored unfavorable facts, such as with regards to inadequate worker safety processes. He gave several examples of the bribing of auditors so that auditors' reports would not require the investment of millions in improving conditions in factories and in plants. Today, using the fig leaf that audits provide, corporations seek to convince consumers, regulators, and perhaps even their own consciences that their supply chains are clean and compliant with U.S. law, including the provisions of the Uyghur Forced Labor Prevention Act and Section 301 of the Trade Act, both of which prohibit the importation of goods made with forced labor. In a nutshell, however, as our witness Scott Nova will testify, quote, social auditing in practice involves giving unqualified people inadequate time to pursue an unrealistic objective they have no incentive to achieve, close quote. In a country such as the People's Republic of China, where independent labor unions do not exist, social controls prevent the free exchange of information, and recently passed national security laws make the disclosure of information that portrays China in a bad light a national security offense. Social audits are particularly laughable. But beyond aiding and abetting the human rights abuses that forced labor entails, companies whose supply chains are tainted also undercut American manufacturers at home, such as the textile industry, whose ability to produce quality goods at an affordable price is undercut by importers who drive costs down by essentially utilizing slave labor. Such labor may come from prisons in the Chinese Laogai system or from Uyghurs detained in so-called vocational skills education and training centers, or otherwise assigned by poverty alleviation through labor transfer programs to toil elsewhere in China. These corporations profit from the sweat of the brow of Uyghurs and other labor abuses victims in China, while beggaring their fellow Americans seeking to earn a decent wage in factories in the United States. I do look forward to our distinguished witnesses today to expose the deception inherent in the use of social audits to whitewash corporate complicity in labor rights abuses. I would like to receive input on regulatory and legislative gaps that they think we might plug. We also hope to hear their thoughts on, particularly on enforcement of existing legislation, including the UFLPA. Pardon me. Also, I'd like to suggest that our securities laws, in particular our 1934 Security Exchange Act and Rule 10b-5 promulgated under it, be put to greater use. That rule, as people are aware, prohibits only untrue statement of material fact as well as any omission of material fact. As we go through annual reports and offering statements of publicly traded companies, we should ask whether they are disclosing to their shareholders and potential shareholders that their supply chains may indeed be compromised by forced labor in violation of U.S. law. Are they disclosing the potential loss of goodwill and harm to reputation, which a company revealed to be benefiting from forced labor in their supply chains to the detriment of their share price? To date, many corporations seem to be relying on these social audits to shield themselves from potential liability. Social audits, which today's hearing along with the good work which has been done by several of our witnesses, will be shown to be the works of near fiction when it comes to accurately portraying the state of labor in the People's Republic of China. Compliance departments, please take note, as well as the law and accounting firms that sign off on corporate disclosures. Following this hearing, I intend to write to the Securities and Exchange Commission, and I invite my commissioner colleagues to join me to ask that they review disclosures by publicly traded companies to assess whether they contain any material misstatements or omissions with regards to forced labor in their supply chains, and if they do, take enforcement action against them, levying fines. Well, the SEC proposed rules in May of 2022 to clarify how investment funds may promote adherence to voluntary environmental, social, and governance standards, another fig leaf utilized by corporations to signal their virtue to consumers, but which remain untethered to the objective criteria. That is only a tentative step which emphasizes the E in the ESG and is addressed to investment funds doing little to confront the issue of forced labor in supply chains. Further, if corporations are not policing themselves and the SEC is slow in responding, then I hope the plaintiff's bar will help discipline these companies seeking to recover any loss in shareholder value that results from regulatory action and exposure of corporate audit washing. Finally, I would anticipate a future hearing whereby we invite auditing companies, such as Longing Company, implicated in the Volkswagen scandal that we shall hear about shortly. Whistleblowers and lowest price retailers such as Walmart would also be asked to testify. I'd like to now turn to co-chair Senator Merkley.
Thank you, Chairman Smith, for this hearing. For 2 decades, this commission has reported on how the Chinese government's failure to provide basic human rights protections has had a detrimental effect on the lives of people living in China. Today, we're focusing on the fact that this same lack of protections has a negative impact on American consumers. It's not a new story. We've known for years that substandard worker rights and lack of transparency in China has resulted in defective imports, such as lead-based toys used by American children. Our first witness, Deputy Undersecretary Thea, who we're so pleased to have her and who serves as a member of this commission, is a longtime expert and champion on this issue. 4 years ago, this commission, based on research of another of our witnesses, Adrian Zenz, and others, published a report showing how products made with forced labor of Uyghurs and other Turkic people in China was coming into the United States. The fruit of this research was the Uyghur Forced Labor Prevention Act, which banned imports of such goods and helped spark a much wider awareness of the need to rid our supply chains of forced labor. Key to the effort to know whether supply chain is clean are the audits performed on the companies who are part of that chain. In 2021, the Biden administration issued the Xinjiang Supply Chain Business Advisory, which assessed that, and I quote, "In and of themselves, third-party audits are not a sufficient due diligence program and may not be a credible source of information for indicators of labor abuses in the region." End of quote. With the enactment of our Uyghur Forced Labor Prevention Act, this warning has become a hard reality for companies importing from China. They now have to provide, quote, "clear and convincing evidence" that their products were not made with Uyghur forced labor. This is the core question for today's hearing. Are the audits that importers cite to meet the law standard reliable? Do they have integrity? Are they genuine? Are reliable audits even possible in an environment where the Chinese government does not allow workers to speak freely, harasses auditors conducting due diligence in Xinjiang, and prevents auditors from obtaining information needed for their job? If a company cannot say with precise certainty to our government and to its shareholders, and most importantly to American consumers, that its products do not contain forced labor, then it needs to stop doing business there. Let's remember that our aim is not to punish companies simply for doing business in China. Our goal is to improve the human rights situation in China so that businesses can certify that their supply chain is free of forced labor and that their suppliers provide good working conditions and wages to their workers. And we ask these companies to partner with us in working towards that goal. We have an impressive set of witnesses, and I look forward to hearing their analysis and their recommendations. Thank you, Mr. Chair.
Very pleased to welcome Senator Butler. Any opening comments? Okay, thank you. Ranking Member McGovern.
Thank you very much, and I apologize in advance. I'm in between two hearings at once, but I want to wish everybody a good morning, and I join my colleagues in welcoming our witnesses and the public to today's hearing on audits and certifications of supply chains in China. You know, this hearing continues the work of the Congressional-Executive Commission on China has done to shine a light on the use of forced labor by the People's Republic of China and to ensure that Congress is doing everything it can to bring an end to the practice. We are motivated by the terrible toll of forced labor on those subjected to it, especially the Uyghur people in Xinjiang, and by its impact on Americans. U.S. consumers should not have to worry about whether the products that they purchase are tainted by forced labor from China. U.S. workers and producers should not have to compete with companies that rely on forced labor. Congress took a major step in 2021 by passing the bipartisan Uyghur Forced Labor Prevention Act, legislation I was privileged to lead. The UFLPA creates a rebuttable presumption that all goods produced in the Xinjiang region of China are made with forced labor. This means the burden of proof lies with those who want to import goods into the United States to show that their supply chains are free of forced labor. The logic behind the law was that it would create incentives for stakeholders, including the PRC, to change their practices. The good news is that companies have responded by implementing their economic, social, and governance, or ESG, policies and contracting social compliance audits to certify that the supply chains for their products are free of forced labor. The problem, as we will hear today, is that even when these audits conform with industry-wide ESG standards, they may not be reliable in the Chinese context. This is both because the companies themselves pay for the audits and have a financial stake in clean findings, and because the PRC, instead of correcting course and ending the use of forced labor, has chosen to retaliate against those who do the audits or cooperate with them. I want to be clear on this point. The PRC government could react to the worldwide concern that has been raised about its use of forced labor by taking the opportunity to end the practice, which, by the way, would be consistent with its obligations under International Labor Organization conventions, all of which China has ratified. Instead, the PRC has taken steps like shutting down the offices of Shenzhen Verite, the Chinese affiliate of the social auditing firm Verite, which is based in my district, reportedly because the company was being a little too accurate about Uyghur forced labor and supply chains. Since 2021, the PRC has adopted laws, regulations, and practices that seem designed to limit the effectiveness of social audits in detecting the presence of forced labor in supply chains. And one example is an anti-foreign sanctions law that has been used at least once to go after a U.S. due diligence firm for collecting Xinjiang-related sensitive information. A second is a broadened definition of espionage that came into play when PRC authorities detained staff at another due diligence firm that was reported to be conducting investigations on forced labor in supply chains linked to Xinjiang. Of 29 firms listed by Social Accountability International as qualified to conduct certification inspections of manufacturers in China, 5 have announced they will no longer conduct social audits in Xinjiang because conditions simply do not allow them to do so. In light of this, our question today is what more Congress may be able to do to help to reinforce the incentives in the UFLPA. Are there steps we could take to strengthen the integrity of auditing mechanisms and make them more independent? Are there other ways to foster increased transparency of supply chains that do not backfire on those who try to do the right thing? So let me just close by emphasizing that we are not here to force companies to leave China. Our consistent goal is to help improve the human rights situation in China. But there is a possibility that the PRC's response so far to the global condemnation of its use of forced labor could lead companies to decide on their own that it is just too risky to do business in China because the lack of human rights protections doesn't allow them to reliably comply with their own ESG policies. And with that, I thank the chairman for giving me the time, and I yield back.
Thank you. I'd like to now welcome our very distinguished witness, Deputy Undersecretary for International Affairs, Thea, who is no stranger to this committee and has been a leader for decades. I remember when you were at the AFL-CIO, and your testimony was brilliant back in July of 2012. You pointed out that the Section 301 is, useless if you don't use it, and pointed out that at the time the Bush administration twice rejected requests, which I and others had all supported, to use it. One of the things that I am is nonpartisan when it comes in aggressive terms to human rights. You speak out, and no matter who is in the White House, it doesn't matter. Well, the Bush administration dropped the ball big time, and you pointed it out in your testimony back in July of 2012. So thank you. We need to use all the tools. And as you said, if there's no tool, there's a tool, but it's not used, what good is it? You've been advocating for worker rights both domestically and internationally for over 30 years. You was president of the Economic Policy Institute, a pro-worker Washington think tank from January 2018 to May of 2021, and an international trade economist at EPI in the 1990s. From 1997 to 2017, Deputy Undersecretary Lee worked at the AFL-CIO, the voluntary federation of 56 national and international labor unions that represents 12.5 million working men and women. At the AFL-CIO, she served as Deputy Chief of Staff, Policy Director, and Chief International Economist. She served on the State Department Advisory Committee on International Economic Policy, the Export-Import Bank Advisory Committee, and on the boards of directors of the National Bureau of Economic Research, the Congressional Progressive Caucus Center, the Center for International Policy, and the Coalition on Human Needs, among others. She served on the U.S.-China Economic and Security Review Commission from 2018 to 2020, and happily, on 2022, you were appointed to this commission, and we're so glad to have you. Ms. Thea, the floor is yours.
Thank you so much, Chairman Smith, Co-Chair Merkley, honorable members of the commission, for inviting me here today and also for holding this very important hearing. I am honored and thrilled to be here. So I head the International Labor Affairs Bureau at the Department of Labor, ILAB. It plays a pivotal role in promoting and protecting workers' rights worldwide. By advocating for international labor rights and protecting them, including the rights to organize, bargain collectively, to have safe working conditions, and to be free of child labor, forced labor, and discrimination, ILAB contributes to creating a more equitable global labor landscape. The issue of factories and fraud in China is multifaceted, with significant implications for human and labor rights and the integrity of our global supply chains. Today, I will address 2 related issues. First, the challenges and risks for businesses of using social compliance auditing as a definitive assessment of labor conditions in general. And second, the heightened risks, given the ongoing human and labor rights violations in Xinjiang Uyghur Autonomous Region, of making reliable audits in the region impossible. Social auditing can be a useful tool to assess compliance at a particular point in time, but it cannot be the only mechanism for detecting labor rights violations and abuses. As we'll hear more about today, audits are often announced in advance, giving managers time to prepare the facility. Managers can easily, and do, fake timesheets to skirt pay and overtime laws, and workers may be pressured to provide inaccurate information. To be effective, social auditing should be part of a comprehensive social compliance system that ensures that unions, democratic worker organizations, and other worker representatives provide support and voice for workers to identify and raise concerns and collectively advocate for their rights and interests without fear of retaliation. iLab's tool, Comply Chain, provides examples of best practices in this area. Worker voice and the ability to freely express concerns are essential. When authentic worker voice exists, workers can freely elect their union representatives, identify problems, negotiate agreements, and hold parties accountable. iLab recently commissioned Penn State University to provide a report, Worker Voice, what it is, what it isn't, and why it matters. I recommend this report to all of you. It provides important insights on why legitimate, authentic collective worker voice is critical to ensuring social compliance, and it provides 6 elements that we need to look for to know. It's clear that effective worker voice is impossible when workers are trapped in state-sponsored forced labor, where there are no independent democratic unions, as Chairman Smith mentioned, and where workers continue to face threats and reprisals. This is the situation we face in China. There are widespread restrictions and repression of freedom for human rights defenders. There is not just a lack of civil society presence, rather the entire civic space has been shut down. In Xinjiang in particular, ethnic minorities live in fear of the Chinese government. Any audit occurring in Xinjiang cannot be conducted without government oversight, making objective worker interviews free from reprisal an impossibility. As the U.S. government highlighted in the Xinjiang Business Advisory published in 2021, updated in September of 2023, as Senator Merkley mentioned, auditor interviews with workers cannot be relied upon given pervasive surveillance, the threat of detainment, and evidence of workers' fear of sharing accurate information. And we have heard that auditors have been detained, harassed, threatened, or stopped at the airport. This is why dozens of major audit firms have not operated in Xinjiang for years. The fear of reprisal for both workers and auditors remains high. Social audits in China should not be seen as an authoritative source for companies reflecting on-the-ground human rights conditions. The business community needs to be aware that any audits, and frankly, any business operations undertaken inside China, carry heightened labor and human rights risks. In conclusion, ensuring workers have a substantive role and voice in social compliance is essential to make social compliance audits legitimate. Without workers' feedback, input, and support in resolving issues, labor exploitation risks in supply chains around the world will unfortunately persist. The Department of Labor is proud to serve on the Forced Labor Enforcement Task Force to support implementation and enforcement of the Uyghur Forced Labor Prevention Act. UFLPA is a powerful tool to address egregious human and labor rights abuses and to ensure that U.S. workers and businesses have a level playing field. We will continue to leverage that tool to protect the integrity of lawful trade, the rights of workers, and continue to raise these issues and call for change. I thank you for your attention, and I look forward to the rest of today's hearing.
Thank you very much, Ms. Lee. And again, thank you for your decades of very, very effective advocacy for worker rights around the globe, including in China. Could you, pardon me, would you tell us what a good worker-driven social compliance program might look like? Can you tell us more about what iLab means by worker voice? And while you're answering that, you know, we all know, I think, in this room that there is no independent labor union in China. But I'm amazed sometimes when I hear in talking to members of the business community how they have a labor union run by the Chinese Communist Party, of course. And I mean, it's such a surface appeal argument that's used to suggest that somehow they're looking out for the rights of their own people. And we know for a fact, based on even the reporting we get out of China itself, that occupational hazards and deaths and maiming and loss of limb is very, very high, and it's grossly underreported. But there's no independent voice ever. It's always whatever the Chinese Communist Party wants us to see. So if you could maybe address those two issues, a couple of issues.
Thank you so much, Chairman. So what should a good worker-driven social compliance program look like? Of course, it would be based on international standards. The International Labor Organization fundamental principles and rights at work. But also, and the key thing, what I mentioned earlier, is that workers and their organizations have to be directly involved in the creation, the negotiation, and the implementation of any social compliance program, because that's where the trust comes from. And I think one of the issues that we will hear about more today is about whether workers feel comfortable coming forward and telling the truth. If you sit a worker down in the middle of a factory and say, "Are you working voluntarily?" They're in the spotlight and they know that the auditor is going to leave. But the union doesn't leave. The union is there 24 hours a day, 7 days a week. It has the trust. It's also cheaper than a social auditing program. The third piece is that these provisions cannot be optional or voluntary, because we know that doesn't work. So the best practice is binding and enforceable agreements between brands and their suppliers, to which workers are also a party. So we've seen this work around the world. The Dindigul Agreement in India was an agreement between the Tamil Nadu Textile and Common Labor Union, a union of Dalit women workers in India, but also H&M, Eastman Exports, and civil society organizations, and the government got involved. That played a critical role in modifying the withhold release order against Nachi Apparel, a garment maker owned by Eastman Exports that had a record of systemic physical and sexual violence in the workplace, an indicator of forced labor. So worker organizations came to the table with the brands and were able to negotiate an agreement that made a significant change and actually lifted a trade measure. And finally, companies need to give space and capacity for suppliers to have the financial incentives for compliance. A lot of what this means is they need to pay a fair price to their suppliers. They have fractured their supply chains deliberately, and then if they pay too low a price and then hire an auditor to review the conditions, that's a little bit disingenuous, because they're paying nothing and they're saying the workers should be treated well. And those two things don't go together. So that's, I think, one of the things that companies need to do. I'm happy to talk just a little bit more about the Worker Voice project that we asked Penn State to do for us. And there are the 6 components that we have found. And I think these are really useful. This is all on our website. First is elect. The workers have to be able to elect leaders free from interference by employers or the government. The second is represent. Workers need to know their rights. They need to be engaged and mobilized. And elected leaders have to be accountable to their members and responsible for consulting with them. Inclusiveness, so that worker organizations need to make sure, including the leadership, that they are representing the full breadth. So, for example, if a union says, well, we're not representing the migrant workers or the people who speak a different language or who come from a different place, then they're not doing their job. So a real worker voice includes inclusive leadership. Protect. Workers have to be protected from retaliation when they speak up, including protection from losing their jobs or deportation or facing abuse, including harassment, threats, violence, and coercion. Enable is the 5th one. Workers need to have the time and space to organize and engage in their union business and the training information to fulfill their rights. And empower. They have to be empowered by the labor laws, have the ability to pursue lawful actions, including strikes, and have access to effective mechanisms to file grievances. So I think those 6 elements are very helpful. And just briefly, in terms of the question you asked about unions in China, I had some experience when I was working for the AFL-CIO. I was able to go visit a company, and it was a big name American company or international company that had 23,000 workers. And I was taken around. It was not an investigation. It was just a visit, talking to the managers. And they had social auditors in there every week, Phillips Van Heusen, Ralph Lauren, very fancy brands. So they were very used to having people come in. And I asked, do the workers have a union? And there was a back and forth. The translation took about 10 minutes because they were trying to explain to the guy, like, what's that? And finally he said, oh, you mean the Happy People Committee? And I was like, well, I guess. And he's like, oh, yeah, we have that. We have a Happy People Committee, and they go on shopping excursions and so on. But the fact that there were social auditors in this factory every week, every day, and none of them had asked that question when all these companies had in their code of conduct freedom of association. So, when a company operates in China, it knows it doesn't have. The workers do not have the ability to have an independent democratic organization because it's not allowed. The laws of the land, so the empower piece of the worker voice isn't there. So I think it's an essential piece, and really any authoritarian, repressive government can't tolerate independent democratic unions because they are a threat to authoritarianism. But that's why they're so important, and that's why I think it's right that we lift that up when we have this conversation about the failings of social audits.
Just to ask you, are there any examples where workers have spoken out candidly to the auditors, but have been retaliated against? And what response did the auditors take? Did they keep it all internal? Did they go public with it? Do they hear things that could make a difference if they would just speak up?
That's an excellent question, Chairman, and I think probably it happens every day, that workers say things and the auditors can leave and the workers can lose their job. I don't think it's that easy for the auditors even to find out if there have been there's been retaliation after they're not on the premises anymore. Do they go back and say, whatever happened to Joe and Sally? Are they still working? Or did they get a raise? Did they get put on the night shift? And so on. And I think that's one of the weaknesses of the social audit is that, unlike a union, the social audit parachutes in, parachutes out, and doesn't have the ability to have that constant piece. So I think, unfortunately, sadly, it's something that happens all the time, and maybe it's something also where workers anticipate that there will be trouble, even if they can't imagine that they can answer that question honestly, and so they do not because they are looking to avoid trouble.
When workers are interviewed in small groups or even alone, how are they picked by these auditors? If it's done randomly, you'd say, okay, there's some validity to that. But then I could see a worker saying, oh my God, I've got a target on my back as I walk out the door. As you said, there's surveillance everywhere, and nothing is between them and the auditor. It's between them and the Chinese Communist Party. How can we expect any kind of good outcome from this? And again, I go back and I've reread some of the testimonies from July of 2012, and it's like it's deja vu all over again. We're right back where we were in a very real way. Maybe it's even worse because we kid ourselves that somehow we're making progress. I'm not talking about the work you're doing, it's great, but I'm talking about in terms of what these corporations are doing. I'm for card check here. I know how the management can intimidate, even here in the United States of America, but there are ways of coming back, forming, and creating a union that then has their backs. There's nothing like that. And finally, and I'll yield to my good friend, the co-chair, the ILO, have they been aggressive in promoting free trade unions and worker rights? The 6 points you pointed out are like, the prescription for exactly what needs to be done. Does the ILO really engage, or are they, just put out a report here and there?
A lot of excellent questions. In terms of how workers are chosen, I think too often, sometimes handpicked workers are chosen by management that the management knows will give the right answers. And in other cases, I'm not so familiar with the auditing processes to know exactly how they're done, but I think also the best practice, I know from my days as a board member on the Worker Rights Consortium, is that the best practice is to do off-premise interviews so that management's not breathing over your shoulder and looking over you and keeping track of everything. But of course, that's not possible in Xinjiang, as we've talked about, that there's no possibility of saying, we're going to go to workers' homes, we're going to talk to workers after they get back from their fishing trips and so on. In terms of the ILO, the International Labor Organization is an extraordinary organization, and it's tripartite, as you know, so it has representation of governments, workers, and employers. And sometimes that means it can move slowly and seeking consensus, but our experience is that the ILO has been a very valuable partner in a lot of parts of the world because it provides the credibility and the authority in terms of judging whether countries' laws are in compliance with ILO international standards or not, and also has been a valued partner to us in implementing technical assistance in many countries around the world.
Senator Merkley?
Thank you, Mr. Chairman, and thank you, Deputy Secretary. We really appreciate your breadth of experience here. When we started to highlight the issue of slave labor in China, China could have responded by changing their practices, but they didn't respond that way. They responded with a series of laws that make it hard to collect information. And as I understand it, they passed in 2021 the PRC data security law. They passed the anti-foreign sanctions law. They passed amendments to the counter-espionage laws 2 years later. And just to give a few examples, in December 2023, they put sanctions on a company for collecting, an American company for collecting Xinjiang-related sensitive information. In March of 23, under the counter-espionage law, they detained employees of Mintz Capital who were investigating the use of forced labor. So essentially, based on everything that you have mentioned and the application of these additional laws, U.S. companies have this challenge in which if they follow U.S. law to really get the information they need to make sure they don't have forced labor, then they're in violation of Chinese law. And if they don't do it, they're in violation of American law. And so it seems like under the current conditions described, this is a situation where the company can only really remedy by moving their supply chain out of Xinjiang. Is that where we end up in all of this?
Thank you, Senator Merkley, for that excellent question. And I think at the end of the day, that is the message from the business advisory, the U.S. Business Advisory in 2021 and 2023, that since you cannot do due diligence in Xinjiang or with Xinjiang workers, then you cannot responsibly operate there. And that would be my advice to companies. And I think that, of course, is the genesis of the Uyghur Forced Labor Prevention Act. It is impossible to do due diligence under those conditions where it has been made essentially illegal by the Chinese government. If it is impossible to do that, then the only responsible thing to do is not to operate in that atmosphere. And hopefully, I think as all the members of the Commission have said today, the goal is not to the goal is to bring about the change, is to convince the Chinese government to stop these practices.
So let's take it to a second point, which is when essentially workers from Xinjiang are taken and transported to other factories. Is that, say they're transported to significant distance outside of Xinjiang, is there, in other parts of China outside of Xinjiang, is it possible to conduct audits in a more effective manner?
I think the labor transfer program, as you say, has been growing. It is a significant problem. It is also covered by the Uyghur Forced Labor Prevention Act, and it is a means both to circumvent some of the protections in Xinjiang and also to depopulate Xinjiang. So I think that the labor transfer program presents significant challenges. I have not seen an effective way to address the challenges of monitoring the labor transfer program workers outside of Xinjiang.
Is it possible to determine whether your subcontractor is using transferred labor?
It ought to be possible, but it's very challenging. It's very difficult. And I know that on the Forced Labor Enforcement Task Force, we've faced a lot of trouble trying to get verifiable information about the labor transfer programs. There's information that's sometimes provided on Chinese websites, and then it disappears. And a lot of the information is not as fresh as we'd like because there isn't the access. There is not the free access inside of China to workplaces, to workers, to be able to assess effectively who the workers are and where they've come from.
So you mentioned a tool which is binding agreements with suppliers, between a company and suppliers. But how does that solve this problem if we can't really audit what's really going on with that subcontractor?
I think the enforceable brand agreements require that workers be able to have a voice and sit at the table, and that I don't think is possible at this moment in China. That it's possible outside of China, and we've seen it, the Bangladesh Accord, the Pakistan Accord, the Dindigul Agreement, and there are other sort of nascent examples of this, but I don't see, I mean, also the government can't be hostile to the enforceable brand agreement. In many cases, like the Dindigul Agreement, the government has been a partner with the businesses and with the union in putting something together. And so that would be an essential element.
So one effect of the labor force agreement or the bill that Marco Rubio and I really championed in the Senate was to essentially encourage companies, because of these situations, to find alternative supply chains in other countries. We thought that perhaps as that starts to happen, that would send a message to the Chinese government, and they might say, we want to retain these companies' factories in China. We might see a change in practice. Has there been any sign that as companies seek to get alternative production sites, that China might be reconsidering the way it conducts business?
I think it's early to say, but I think our experience with some of this is that a lot of those decisions are going to happen in a very closed way. Like, for example, with South Africa and apartheid, during a lot of the period of agitation and activity and divestment from South Africa, the message from the outside was the South African government doesn't care, you're just hurting the people you're trying to help. But at some point, it becomes untenable for the government to proceed. And my hope is that that is the direction that we are going. We've seen that there has been production diverted outside of China. I think also with the European Union moving in the direction of putting in place their own forced labor import ban and their own mandatory due diligence, which just happened last week, that you're going to see increased pressure on China from other markets. And that's something that I think we've talked about before. Canada and Mexico have also instituted forced labor import bans. As other countries come on board, Australia, other countries are looking at this, I think at some point, it becomes untenable for the Chinese government to continue business as usual.
I'm out of time now, but I'll mention two things. One, I'd like to follow up with further questions in written form about the Comply Chain initiative from the International Labor Affairs Bureau and how that fits into this. Second of all, I was just up in Canada on the Plastics Treaty in Ottawa and was having conversations with Canadian officials about them joining us, because right now a lot of products that are turned down in the U.S. are shipped across the border into Canada, which is an escape valve that makes it much less effective. But I think this Uyghur Forced Labor Prevention Act is really a milestone in trying to take on horrific labor practices and terrible human rights violations by China. I hope we can keep pushing to make it more effective.
I agree with you, and I thank you for the work that you did to implement the Uyghur Forced Labor Prevention Act. And just one quick thing with Canada, we have actually, iLab and Canada and Mexico are carrying out trilateral training and technical expertise exchanges with respect to the forced labor import ban. We brought our customs, trade, and labor officials together from the three countries repeatedly for several workshops that I think has been very valuable. So we are definitely looking to strengthen the ability and the capacity of both Canada and Mexico to enforce their own laws.
Great. Thank you.
Thank you, sir.
Thank you, Senator. Just a final question. I chaired a couple of hearings on the growing use of forced labor to mine cobalt out of the DR Congo. And in the past, I've been to Goma. I've been to places where this occurs, but not recently. But we know from our hearings that something like 25 to 40,000 children are being exploited in those mines, and about 200,000 adults. It's all going to China. China is running the mines. And, in my opinion, if somebody wants to buy an EV or that's all up to them, but it should not be on the backs of little African children who are being hurt and some killed as they are mining this. Now, are you aware of any auditing that is occurring? I did ask Secretary Curry this when he was still the czar for green initiatives. And he said there's an MOU that they're working up or have worked up, and I've seen it. And to me, it's all aspirational. It doesn't have any teeth whatsoever with DR Congo and the United States to try to, if you're going to mine it, process it there. Don't send it to China where they perhaps, again, use forced labor or anything but free workers to process it. And I'm wondering if there's been any audits of that industry, the cobalt industry, especially since we know without any doubt that there's exploitation in the extreme occurring as it's mined by China, and then it ends up in our showrooms, in our car showrooms. Is it being audited by anyone?
Thank you for that question, Mr. Chairman. And it's actually, iLab has a project that is trying to trace the cobalt from the artisanal mines all the way through the production process. It's been a little bit challenging. We're working closely with the Ministry of Mines and the Ministry of Labor in the DRC. It's difficult. And as you say, for the exact reasons that you say, that both the mingling, the commingling of the artisanal cobalt mines and the industrial mines, they're right next to each other sometimes, and they are by design sold to the Chinese processors, and they go to China for processing. It's very difficult to separate that out. We have several projects going in the DRC on exactly this issue because we consider it very urgent and very serious. So we are working both with children and communities and their families. We're working with the Labor Inspectorate. We have supporting them in getting more training and more resources. And in fact, the DRC Labor Ministry has moved to hire 2,000 inspectors and administrative officials to improve their labor inspection system, which is a huge start. It's pretty amazing, but they have not had any capacity whatsoever to do the labor inspections in the main mines. So I think we're working very slowly in that direction, and I know there are also efforts to do more of the processing in the DRC, which they aspire to do, they would like to do, and that would solve one element of the problem. So I agree with you that this is a very serious issue, and we are doing everything in our power both to get more transparency and information, but also to build some capacity amongst the key players there.
I would respectfully ask if you could take a look at two bills that I've introduced. One would provide a rebuttable presumption with regards to the cobalt, and if it's a clean supply chain, then have it come here. But I believe it is so egregiously tainted that there's no way that can be done. Secondly, so that's the first bill. That has not moved. The second bill has moved. The Ways and Means marked up on my bill to create a strategy and do some other things vis-a-vis the cobalt industry in China and DR Congo, and that was marked up in the Ways and Means Committee last week. So I would ask if you could take a look at it, provide any insights you might have, hopefully the support of the administration, because we know even when things pass here, they very often have a rough road in the Senate. And from my point of view, having had those hearings, having heard from witnesses about not just the kids that are exploited, but also the adults. They're not being paid. They're getting sick. They're often going into the mines without appropriate protection gear, and they're being worked by the Chinese Communist Party, who are overseeing all the mines. And 70% of all the cobalt is coming from there. So it's very, very serious. And I think we've got to really get ahead of this one. Finally, I'll just say, so please take a look at those. Scott Nova, Executive Director, who will be speaking of the Worker Rights Consortium, said social auditing in practice involves giving unqualified people inadequate time to pursue an unrealistic objective that they have no incentive to achieve. What a paragraph, or what a sentence. Do you agree with that?
Yes.
Okay, thank you. I really appreciate your testimony and look forward to hearing from you on the other bills too. Thank you.
Thank you so much, Mr. Chairman.
I'd like to now welcome our second panel, and thank you, Secretary Lee. Beginning with Scott Nova, who is the Executive Director of the Worker Rights Consortium, WRC, an independent labor rights monitoring organization that has conducted investigations of working conditions in factories around the globe, including in China, Vietnam, Myanmar, and other countries where severe restrictions on civil society pose special obstacles to labor rights inquiry. Mr. Nova is a leading expert on the aspects of labor rights investigations and on the practices and performance of corporate social auditors. He has written and spoken widely on the intersection of international commerce and worker rights. Really happy to have him here, as well as our other witnesses. Adrian Zenz, Dr. Zenz is the Director of China Studies at the Victims of Communism Memorial Foundation here in Washington, D.C. His research focuses on China's ethnic policy, Beijing's campaign of mass internment, securitization and forced labor in Xinjiang, and public recruitment and coercive poverty alleviation in Tibet and Xinjiang and China's domestic security budgets. Dr. Zenz is the author of Tibetans Under Threat. He has played a leading role in the analysis of leaked Chinese government documents, including the China cables, the Caracas list, and the Xinjiang papers and the Xinjiang police files. Then we will hear from Jim Wormington, who is a senior researcher and advocate of the Economic Justice and Rights Division at Human Rights Watch, where he works on extractive industries, supply chains, and other issues related to corporate accountability. He was previously a researcher in Human Rights Watch's Africa Division, covering human rights issues in West Africa. He is an English-trained barrister, part of a member of the QEB Hollis Whiteman Chambers, and was educated in Cambridge and New York University of Law. He recently co-authored the report, Asleep at the Wheel, Car Companies' Complicity in Forced Labor in China. I'd like to now turn the floor to Scott Nova.
In assessing the validity of labor auditing schemes in China, it is necessary to bear in mind the checkered history of such schemes globally. So-called social auditing has public relations value to corporations keen on convincing us they are operating their supply chains responsibly, but has often been of little value to workers. The examples of social auditing's failures are voluminous and tragic. The worst factory disaster in human history happened in Bangladesh in 2013, when a building collapsed and killed 1,100 garment workers. The building had been repeatedly inspected by social auditors working for Western brands. So had the dozen other garment factories in the country where workers died en masse in fires and structural failures over a period of years due to egregious safety deficiencies. These factories were death traps before they were audited. They were death traps after. Examples of the failure of social auditing can be found in every industry and in any country. Among the most notable is the long history of auditing failures at Foxconn, Apple's primary supplier in China. Among the grim consequences were worker fatalities from easily preventable explosions, tens of millions of dollars in stolen wages, and inhumane conditions that led to a rash of worker suicides. These failures are the product of flaws inherent in auditing systems. For corporations to claim that their auditing schemes provide a meaningful umbrella of protection, these schemes must be comprehensive, with regular inspections of thousands of production facilities across a supply chain. The only way to conduct thousands of inspections annually at a cost considered affordable by corporations seeking to produce as cheaply as possible is to assess hundreds of compliance standards, even at the most massive facilities, in 1 to 2 days. Such inspections are superficial by necessity. So are the skills of the auditors. In the US, we have numerous different regulatory agencies responsible for the enforcement of labor laws. Within each are multiple categories of specialists. This is typical of regulatory systems because of the extensive expertise required to handle each specific issue. Social auditing systems ask each auditor to handle every applicable standard. Each is a jack of all trades, a master of none, carrying out specialized tasks without specialized training. How did thousands of audits in Bangladesh miss the hazards that threaten workers' lives? Because the auditors had no training in identifying such hazards. This didn't stop the firms they work for from issuing the factories a passing grade. Even more problematic are the conflicts of interest inherent in the system. U.S. corporations don't produce in China or Guatemala to uphold labor rights. They do so because it's cheap. Since it costs more to produce under good conditions than bad, promises corporations make to improve conditions through auditing conflict directly with their financial imperatives. Corporations don't audit to find out whether they need to change their supply chains. For example, leaving a country where the labor environment guarantees abuses. They audit because they want to preserve lucrative sourcing strategies and need to convince policymakers and customers that those strategies are somehow compatible with humane treatment of workers. That goal is not served if auditors consistently reveal embarrassing realities. Corporate imperatives shape auditing schemes, not vice versa. The corporations employ the auditors directly or pay contract auditing firms. Unlike financial auditing, where there are rules and regulations designed to preserve the ability of auditors to render independent judgment of a client that is paying them, social auditing is notorious for the lack of any regulatory oversight. Auditors have strong incentive to avoid inconvenient conclusions while facing no consequences for underreporting violations. As the chairman has noted, social auditing in practice involves giving unqualified people inadequate time to pursue an unrealistic objective they have no incentive to achieve. Social auditing is poorly suited to uncovering abuses even in environments conducive to labor rights investigation. An unconducive environment like the one in China makes this mismatch extreme. This raises a vital question. How can U.S. corporations importing from China carry out the due diligence with respect to forced labor they now have a legal obligation to perform? The answer with respect to auditing within the XUAR is simple: they cannot. As this commission reported in 2022, firms cannot rely on factory audits to ensure that their supply chains are free of forced labor. The meaningful audits remain a practical impossibility in the region, which is why no sourcing can be allowed. Many auditors have stopped auditing in the region, some in response to calls from human rights groups, others because the UFLPA has shrunk the market for auditing. Brands that have ceased sourcing from the region have no reason to hire auditors to conduct inspections. However, as UFLPA enforcement accelerates and pressure mounts on industries like solar and auto that have been heavily dependent on the region, there is a risk of a resurgence of efforts to use social auditing within the XUAR as legal and political cover for continued sourcing. Indeed, some auditing firms continue to operate in the region. One is Elevate, one of the most prominent auditing firms in the world. There is also the recent Volkswagen audit of its joint venture facility in the XUAR, an audit so lacking in credibility that most of the staff of the firm that performed it publicly disavowed it. While the impossibility of conducting credible labor inspections within the XUAR is well established, compliance with the UFLPA's ban on imports from factories outside the XUAR that utilize transferred Uyghur workers remains essential to compliance with UFLPA. Since labor transferred from the region has been utilized by factories in many different parts of China, the risk is nationwide. This raises two questions. Are corporations inspecting suppliers to ensure there's no transferred labor? And what methods are their auditors using to overcome the massive obstacles to such inspections? There's little public information available. Most corporations are silent on how they are complying in this area, and no auditing firm has provided any transparency as to methods. We know from private discussions that some auditing firms are claiming they can detect transferred labor, but it is unclear how many corporations are using such services and what methodologies are employed. In our opinion, given the powerful incentive any supplier using transferred labor has to hide the practice, reliably detecting the presence of transferred Uyghur labor requires methods beyond those normally employed by social auditors, including gathering information from facilities workers off-site. Interviewing workers on-site is useless in this context. It is inconceivable that a Han Chinese worker is going to tell an auditor in a conversation arranged by factory managers occurring inside the workplace that Uyghur workers are present at the facility and that management is hiding them. However, based on limited information available, we're unaware of any auditing firms that are using such alternative methods. There's another obstacle to effective audits. The Chinese government is actively seeking to undermine the ability of auditors to expose abuses. Indeed, they are even targeting auditing firms and their Chinese personnel involved in efforts to verify compliance. The Outlaw Ocean Project provides a window into the effectiveness of auditing under these conditions. The project uncovered multiple instances of audits failing to identify forced labor in seafood processing plants in China supplying U.S. firms. All had been certified by prominent bodies that use social audits to verify compliance. In one case, the investigation found Uyghurs working at a plant the same day an audit gave the facility a passing grade. By way of excusing these failures, auditing firms told investigators, and I quote, "Forced labor is notoriously difficult to identify." Indeed. Corporations face a severe UFLPA compliance dilemma, even if they've stopped sourcing from the XUAR. Full compliance requires viable methods to ensure there's no transferred Uyghur labor at suppliers outside the XUAR. The U.S. government should be asking corporations importing goods from China to demonstrate that they have such methods in place. The leaders of any corporation that can't do so must then explain how they know, with respect to any given import on any given day, that they are not breaking the law. Thank you.
Thank you very much, Mr. Nova. Dr. Zenz.
Dear Chairman, dear Co-Chair, thank you for inviting me to testify today. The so-called Xinjiang Uyghur Autonomous Region operates the world's largest current system of forced labor, state-imposed forced labor, with over 2 million Uyghurs and ethnic group members at risk, as we speak. In contrast to most forms of forced labor, state-imposed forced labor operates through a pervasive police state environment. It is therefore often more readily assessed as a risk than a specific instance, because it creates an environment where victims cannot speak freely. As a result, due diligence efforts based on social or labor audits are not feasible, neither in Xinjiang nor in other Chinese provinces that receive transferred ethnic workers. The Chinese government has been hiding related statistics of transfers outside of Xinjiang, but according to my research, the number of transferred Uyghurs was set to increase last year by 38%. Affected companies and supply chains must be considered at risk of being tainted with forced labor. The only ethical choice is divestment. Many auditing companies are either unaware or pretend to not realize that the very nature of state-imposed forced labor and labor transfers means that forced labor cannot be reliably assessed at workplaces. You would have to conduct an audit of the entire social environment. While there have been efforts by companies to divest from supply chains linked to Uyghur forced labor, these efforts remain insufficient. Supply chain transparency remains limited, and this has been severely aggravated by obfuscation efforts by the Chinese state, which is now increasingly criminalizing the collection of data essential to performing due diligence. Germany's chemical company BASF operates 2 joint ventures in Xinjiang. Its joint venture partner Marco has participated in government work teams that entered and spied on ethnic households during the peak of the mass internments. Incriminating reports on Marco's website that I identified and passed to media last year describe staff enforcing assimilatory ethnic unity activities and entering targeted households at night. However, as recent as November 2023, BASF stated that it was in concrete discussions with an auditing firm to renew its Xinjiang joint venture audit in 2024. As we know, of course, these audits cannot uncover these kinds of activities. In December 2023, Volkswagen published an informal one-page PDF billed as an audit of its joint venture factory in Xinjiang. Immediately after the report was issued, the staff of the auditing firm, Germany's Learning, disavowed any connection to the audit. Between then and now, nearly 1/3 of the entire staff at Learning have in fact resigned, presumably in protest. The audit's methodology shed significant doubts on the findings' validity. Volkswagen had disclosed that the actual audit was conducted by 2 Chinese lawyers who were merely accompanied on site by 1 Learning staff member. Marcus Learning's comments to the media suggest that his quotes published by Volkswagen were in fact misleading. In them, Learning claimed that we conducted 40 interviews. However, later he conceded that the audit was mainly based on a review of documentation rather than interviews, given, according to his own words, that interviews would endanger the staff. Learning statements acknowledged that the so-called audit consisted of little more than a visual on-site inspection combined with a review of staff work contracts. Such a review cannot identify state-imposed coercion. Experts have noted that a poorly designed audit is at best meaningless and at worst excuses harms that the audit claims to mitigate. Volkswagen's strategy appears to exploit the fact that no visible signs of forced labor were ever likely to emerge at its facility. By creating the appearance of a genuine audit while measuring factors irrelevant for assessing state coercion, the Volkswagen Learning effort is a paradigmatic and deliberate example of audit washing. In addition, further research I conducted shows that the SAIC Volkswagen test track in Turpan, a Uyghur region, was built by a Chinese state-owned enterprise using transferred Uyghur laborers, according to their own statements. Aside from exposure to coerced labor transfers, internal government documents show that Volkswagen could also be implicated in Xinjiang's camp-linked forced labor system. Following the Learning audit, index provider MSCI removed Volkswagen's ESG red flag rating indicating that Volkswagen can be considered an ethical investment despite its continued presence in Xinjiang. The most recent evidence implicating Volkswagen's test track in forced labor has so far been completely ignored by MSCI. MSCI is rewarding and enabling Volkswagen's audit washing and complicity in the region. This issue warrants further investigation into both the learning audit and into MSCI's methodology. Just in February this year, the International Labour Organization published an update of its guidance, adding a section on state-imposed forced labor and responding to feedback and criticism given by others and myself in my extensive engagement with the ILO last year. And you will find an entire section of that reviewing the implications of these updated recommendations of the ILO in my written testimony. This should be used to investigate and to measure the issues created by audit washing and by questionable methodologies, including by index providers. Recommendations. I recommend that the US government and/or Congress publishes a detailed report about the ways in which the Chinese state impairs the implementation of meaningful audits and intimidates auditors and companies, preventing due diligence. Congress should hold hearings to investigate the experiences of audit providers in China and whether or not they would be willing to conduct audits in Xinjiang. Scott Nova and myself sent a letter to multiple auditors early in 2020, and we only got affirmative responses from a limited number of them. This is an unacceptable situation. Congress should also hold hearings involving Volkswagen to investigate the circumstances of the learning audit and whether the public has in fact been misled by it. Congress should also hold a hearing questioning index provider MSCI and potentially other index providers over its methodology in adding and then removing its red flag rating for Volkswagen without clear and appropriate evidence, and also what MSCI will do about the latest allegations directly implicating the Volkswagen test track in Uyghur labor transfers. CBP should use the Uyghur Forced Labor Prevention Act to require companies whose supply chains involve an elevated risk of connection to products made in whole or part with Uyghur forced labor to disclose their supply chains to the raw material level, and if they're unwilling or unable to do so, then Congress should enact related legislation. Thank you.
Very much for your testimony, expertise, but also those very, very good recommendations. We will follow up. Thank you. Mr. Wormington.
Thank you, Chairman Smith, members of the Commission, for the invitation to be here today. The essential context for this hearing is the long-standing connection between major global industries and the Chinese government's human rights violations, including state-imposed forced labor programs targeting Uyghurs and other Turkic groups. The car industry provides a compelling example of the links between global supply chains and Uyghur forced labor. My organization, Human Rights Watch, in February 2024, published a report describing how approximately 10% of global aluminium, a vital material for car manufacturing and other industries, is produced in the Xinjiang Uyghur Autonomous Region, which I'll refer to as the Uyghur region. Our research showed that aluminum producers and the coal mines and coal plants that supply them have participated in coercive labor transfers, a form of state-imposed forced labor. Aluminum from the Uyghur region is shipped out of Xinjiang, melted down, and used to make aluminum products for car manufacturers and other industries. The hearing today is important because companies and their suppliers in the car industry and other sectors continue, as my colleagues have said, to use social audits to investigate labor conditions at factories in the Uyghur region. And just to be clear, audits are not a credible mechanism for investigating Uyghur forced labor. The Chinese government's use of extrajudicial detention, torture, and enforced disappearances in Xinjiang, as well as mass and intrusive surveillance, pose grave risks to workers. This makes it impossible for auditors to safely and credibly investigate forced labor. Volkswagen's 2023 audit, as Dr. Zenz has explained, exemplifies the problems and pitfalls of auditing in the Uyghur region. I won't repeat what Dr. Zenz said about the audit, but I think it's extremely instructive that Marcus Loning, whose firm oversaw the audit, said afterwards that interviews with workers in the Uyghur region could be, quote, dangerous, end quote, and that, quote, even if workers would be aware of something, they cannot say that in an interview, end quote, from the person who oversees the firm that oversaw the audit. Following the release of the Volkswagen audit report, Human Rights Watch and 61 Uyghur human rights and labor organizations issued a statement criticizing the Volkswagen audit and calling on consultancies and auditors to immediately cease providing services in the Uyghur region. But stopping the use of audits at factories in the Uyghur region is not enough to address the role of audits in enabling connections between global supply chains and Uyghur forced labor. And I think this is, in some sense, the most important part of what I'll say today, which is that stopping audits in the Uyghur region is not enough to stop the connection between audits and the washing of global supply chains. That's for two reasons. The first reason, as Scott Nova has referenced, is that labor transfers are continuing outside of the Uyghur region, and that the question of how you can audit sites and factories outside of Xinjiang is a question and a challenge that all companies operating in China have to confront. And the second reason is that in industries, especially, for example, in the car industry, companies also use what's called supply chain due diligence audits, not to investigate conditions at a particular factory, but to verify whether their suppliers have processes in place that to avoid sourcing products or materials linked to human rights abuses. So those audits don't look at particular factories, they look at the sourcing policies of direct and indirect suppliers. But those audits, as others have said, are still constrained by the threat of Chinese government harassment and reprisals against auditors across China where they are investigating links to Uyghur forced labor. Our own research on supply chain due diligence audits in the aluminum sector revealed evidence that auditors assessing a car industry supplier with evidence of links to the Uyghur region avoided reference to Uyghur forced labor in the audit report due to, quote, the political sensitivity of the issue. This form of self-censorship plays squarely into the Chinese government's efforts to quash discussion of its abuses in the Uyghur region, even for an audit that was happening outside. So the impossibility of conducting credible audits in the Uyghur region, the growing concerns about the obstacles to effective auditing in the rest of China, means that companies should not rely on audits, either as evidence of the absence of forced labor at specific factories, or as proof that a supplier in China is sourcing responsibly and does not have forced labor in its supply chain. Companies should instead themselves map their supply chain and responsibly disengage from joint ventures, subsidiaries, or suppliers who continue to operate or source materials or products from the Uyghur region. I would echo, as others have said, and as Chairman Smith has said, the importance of holding hearings to bring executives from audit firms to Congress to testify about both the obstacles of auditing in China and the efforts that those firms are taking to avoid being complicit in human rights abuses in China and elsewhere. Congress should also hold hearings with key industries, including the car industry, requesting that they testify about the risk of Uyghur forced labor in their supply chains and about their use of audits at their joint ventures and their suppliers, potentially building on the Senate Finance Committee's ongoing investigation into the car industry and its links to Uyghur forced labor. Finally, Human Rights Watch thinks and has said that the Uyghur Forced Labor Prevention Act is an extremely important and effective piece of legislation at stopping imports of products from the Uyghur region entering the US. But for products like aluminium, where the supply chain remains extremely opaque and extremely complex, supply chain transparency is the key obstacle to effective enforcement and prohibition of imports linked to forced labor. So Congress should consider enacting legislation that for high-risk commodities like cotton, polysilicon, and aluminium, that requires companies importing those commodities to disclose their supply chains to prove that they are in fact not sourcing from the Uyghur region. Thank you, Chairman Smith.
Thank you so very much, Mr. Wormington. Maybe you all could give us some insights as to what consequences you think there ought to be for these auditing companies. We will invite them. We look forward to your recommendations as to who. I'm wondering if, if an auditor, obviously they must have some true sensibilities towards the people they're talking to. And when they come back again and find out that Joe or Jim or whoever all of a sudden has disappeared, or they're in the Laogai or their concentration camp for having spoken to them, if they did, are there any anecdotal information on that, or is it all just completely closed? And let me just ask you this: this whole auditors issue reminds me of the charade that we saw going on in the 1990s. When starting with George Herbert Walker Bush, and then followed by very aggressively by Bill Clinton, we had an MOU with China on Gulag labor. And I went over to China several times. I actually got into Beijing prison number 1, where Tiananmen Square activists, some 40 of them, were making shoes for export and socks. And Frank Wolf and I went there, and we took samples out. We got an import ban on that one, but only because we had the information and it was actionable. But every time we would raise it with the administration, they would say, "Oh, we have an MOU," and they would wave it in front of us. And I said, "But it's not worth the paper it's printed on, because if we suspect something, we have no access to the Gulag or the Laogai that's producing this, we tell the Chinese government, they investigate, and 60 days later or so, they give us an account." So I met with our customs people on one of my trips at our embassy, and I said, "Well, how many cases do you actually get?" And they said, "None," because who's going to do it? And even if they had one, they would have to give it to the Chinese police to do a whitewash, which they would do. But at hearing after hearing, we would have administration witnesses telling us how we have an MOU. And now I think, fast forward to today, we have these audits, which thankfully you are helping to expose for the fraud that they are. And we got to come up with something. But what consequences should we be imposing, if any, on the auditing companies? Obviously, most of them are not U.S., if any. And then the companies, at our hearing, and Thea will remember this, we focused a lot on Apple and the others, but Apple in particular, and it's like nothing's changed. And I'm just wondering, 14 years later, after that hearing, we're still dealing with this issue, and the corporations are hiding behind this, see, we got this audit and everything looks fine. And what companies, finally, would you say are the worst violators of using this? You mentioned Volkswagen, and I think that's a very, very insightful case. We'll invite them. Maybe they'll come and testify. It would be great to hear how they square this with good corporate citizenry. But if any of you would like to take a shot at it. Yes, Scott.
In terms of the issue of retaliation against workers who've testified to auditors, it's a widespread problem in the industry, and there's very little follow-up in general from corporate auditing firms. I don't know of any firms that have a proactive mechanism for follow-up, which means in order for them to even find out that something has occurred, either the factory would have to disclose it, which is obviously unlikely, or workers would have to trust the auditor enough to actually reach out to them and complain based on a belief that they'd likely get some recompense as a result. And in general, auditors don't have that trust because from a worker's perspective, an auditor is some group of people who come into the factory under management's auspices, walk around the factory with management and ask a bunch of questions that might as well have come from management. We see this problem frequently in our own investigations. And in addition to the problem of after-the-fact retaliation, there's the problem of before-the-fact coaching, of managers telling workers, threatening them with consequences if they testify, or most commonly simply telling them, if you tell auditors anything negative about our facility, we'll have to close and you'll lose your job. So that's a huge obstacle. On the question of consequences for auditors, this is a really important issue. One obvious possibility is to view the role auditors play in helping corporations hide the reality of their supply chains from relevant audiences in the US, to view it as an act of fraud. and to think about how that could be punished appropriately. Under the Trafficking Victims Protection Act, the executives of corporations who profit from forced labor in their supply chains that they either know about or should have known about can be criminally prosecuted. It's never happened, but the power exists to do so. The power also exists to prosecute the auditors under the same law. And until we see these kinds of consequences, it's very unlikely that we'll see a major change in the practices and ethics of auditing firms and the corporations that use them.
Mr. Wormington.
Yeah, thank you, Chairman Smith. I mean, just to echo a point that Scott made, I think that it is essential to think about what are the legal strategies that can hold audit firms accountable. There is an analogy in the mining sector, which I do a lot of work on, where you have certification systems that purport to certify a particular commodity. It could be gold, it could be cobalt, for example, as being responsibly produced. And in essence, what that certification is saying to the consumer is you can trust the origin of this material, you can trust the origin of this commodity. And so there are ongoing examples of litigation, including in London, where organizations are trying to hold accountable those certification agencies under consumer misrepresentation law because they are misrepresenting to the consumer that something was responsibly sourced when it wasn't. But it's certainly true, I think, that the more legislation we can have to facilitate those kinds of actions, the better. Just quickly on the other companies, the brands, the Apples, the car companies that are implicated, I want to be really clear that our report did include Volkswagen, but the issue of sourcing of materials, not having a factory in Xinjiang, which is the Volkswagen case, but the sourcing of raw materials is a problem that applies across the automotive industry. It's not a Volkswagen-specific problem. And if you are having car companies come to testify about their supply chain links to forced labor, you should absolutely be requiring the Teslas, the Fords, the Mercedes, the General Motors to come and testify about that issue. The other point I just want to quickly make on that front is that we think a lot about imports because of the Uyghur Forced Labor Prevention Act. And of course, we want to make sure we protect consumers globally from imports that are linked to forced labor. But many of these companies also have huge joint venture operations inside of China, for example, including General Motors, including Volkswagen, where in some cases the majority of their cars are actually being sold inside of China and produced inside of China. But those are still US or European companies. And so the question should be asked as to what are the standards that you're applying for sourcing and Uyghur forced labor in your operations and your joint ventures in China, just as much as you are for the cars that are being exported to the US. I think that would be a critical question to ask car makers also if they come to testify.
Thank you very much. Dr. Zenz.
Yes, I would very much agree with the assessment that these sort of pseudo-audits constitute a form of fraud and should be punished as such. And I defer to experts such as Scott Nova, who are more familiar with the existing legal frameworks and how they should be strengthened. I think there's also a real communication problem. So when I, for example, gave the recommendation that the US government or Congress should publish a detailed report about Chinese government impairment and obfuscation of auditing, of meaningful auditing, I think there needs to be a lot more detailed communication, for example, State Department guidance on Xinjiang business advisories or the CBP's guidance on the UFLPA, that with this kind of form of forced labor, you cannot go and audit a workplace and then inspect a workplace and say, okay, well, there wasn't any obvious visual sign of coercion, so we can kind of give this a passing grade. But to really educate and also put it out as a warning sign, to specifically say that these kind of procedures and standards to perform an audit are unacceptable or wrong. And as we know, the UFLPA, unfortunately, there's no criminal punishment component, right? If you violate the UFLPA, your shipment gets detained, you can go and pass it on to the Canadians or whoever else in the world. And that's not much of a punishment if you do that kind of on purpose and use sort of a fraudulent audit to cover it up. And as a side note, on your mentioning of the re-education through labor system, the Laogai system, I think we should keep in mind, I published a research report last year that examines over 30 Chinese academic research articles in which Chinese academics in the 2000s examined the shortcomings of the Laogai forced labor system according to their views. And they said the Laogai system is ineffective, it's not good at re-education, and it's not good at forced labor. It tries to do both at the same time. And the incredible thing is that we see in Xinjiang is the Xinjiang's re-education camps constitute an improvement. They actually took these recommendations and improved the re-education forced labor system by having a dedicated re-education phase and then a dedicated skills training and labor placement process to perform forced labor in private companies. And I think it needs to be recognized how the Chinese state is innovating their mechanisms of repression. Also with the poverty elevation through labor transfer program, how this constitutes an innovation by rendering state-imposed forced labor less visible and more obfuscated and more insidious as a result. And so a lot more work and public communication, I think, should occur, pointing out that fact. Thank you.
Thank you. Secretary Lee.
Thank you so much to all three witnesses for your excellent testimony and the information you provided. You've all raised a lot of interesting points. I guess one thing I'd like to hear from each of you is some concrete advice, and I appreciate some of the suggestions that have come out in terms of transparency and so on for the U.S. government, and particularly the FLETF, the Forced Labor Enforcement Task Force, which I serve on. On the one hand, you're saying we need better guidance for determining what is, in terms of state-sponsored forced labor, but it's a little bit of a contradiction because I would say that the business advisory that came out tells people not to produce there, and so you're either going to give people better guidance, like how do you do an audit in a state-sponsored forced labor situation? Is there even an answer to that question? That if we had a better guidebook that we could improve it. But I guess what I'd really love to hear from each of you is what do you think next steps should be in terms of enforcement? We have this important tool, the Uyghur Forced Labor Prevention Act. We have the withhold release orders. That can be motivating, and the thing that's motivating about it is that it covers the entire supply chain. So in principle, every single thing that is in the auto supply chain is covered by both the Tariff Act of 1930 and the Uyghur Forced Labor Prevention Act. And yet we don't have the visibility or the tools to effectively be able to gather each one. So do you have some concrete suggestions for how we can gain better visibility and better effectiveness in terms of using the tools at our disposal? Thank you.
It's a critical question. And the corporations themselves are carrying out audits every day, specifically around forced labor transfers. And one recommendation would be for the FLETF itself to contact key importers, perhaps the several largest in each of the most important industries, and ask them to proactively demonstrate that they are utilizing audit methods that enable them to reliably detect the presence of transferred labor. If they're not doing that, then it's quite obvious that they cannot know in any given instance whether the products they're importing were or were not made with forced labor in violation of the UFLPA import ban. And then the question is what to do about corporations that can't demonstrate that. And ultimately, I think corporations will have to believe that unless they can credibly verify compliance, that they ultimately won't be able to import. And the time, I don't think there is a way to consistently do, at this point in time, under current political conditions, reliable audits in the country. At a minimum, any individual involved in them is taking a sizable personal risk. And I don't know how in that context you can expect people to do their jobs effectively. I think the Chinese government will have to draw the conclusion that the enormous and relentless obstacles it's putting in place that prevent any kind of meaningful verification are going to have to be reduced. And that if that doesn't happen, that there'll be a mass exodus of investment. And very frankly, I don't see any other scenario in which we see change that doesn't involve that fear existing in the minds of decision makers in the Chinese government, then leading to some softening of the level of repression, surveillance, scrutiny that's making it impossible for auditors to do a credible job.
I think it's great that the Xinjiang Business Advisory is being published. And maybe the best solution is actually to publish a separate document, a separate advisory on auditing in context of state-imposed forced labor, and why that is an inherent contradiction, why the very concept of a standard social audit approach is incompatible with the very nature of how state-imposed forced labor operates. And if you have a document like, and of course the existing guidance, makes hints and says that you can't, reliably assess, you can't interview, etc. But I think it goes beyond you can't interview. There's a lot more factors into it. And I think FLETF could draw on the updated ILO guidance on that. And I've produced a report that actually gives some pointers on that. We actually have some hard copies in the room. And if there was such guidance, which I think should be complemented with a full report documenting the Chinese state's efforts of interference and legal, both the legislation, the national security legislation that basically outlaws data gathering required for conducting a meaningful audit. And you could, of course, include testimonies and the arrest of of members of American auditing companies like Zenz, etc. And if you had these kind of documents, even though they're not legal, they would create a de facto reference point, an anchor point, that companies like MSCI could be questioned against. And I think that would be a start. Based on what methodology did MSCI remove that rating? In light of X, but X needs to be better documented, right? And on an official level, not just by us researchers. And also the Volkswagen, based on what standard of reference do we criticize and say, and the US government, basically it would fail to meet a standard that's effectively of the US government. And the next step after that, of course, would be to punish and declare violations and transgressions that are obvious under fraud, as fraud, or to enact legislation. Maybe we need dedicated legislation that prevents audit washing worldwide, which is a big issue, as we've heard today. It's an issue in private companies. It's an issue in private forced labor, state-imposed forced labor, China, Democratic Republic of Congo, etc., many places. Maybe this is something where legislation needs to really move into. And I think subsequent hearings would be essential in creating a baseline, but also to create information what would be effective. But I think an updated, maybe dedicated guidance on audits, both pertaining to Xinjiang and to transferred Uyghurs in other provinces, a dedicated guidance by FLETF would be like a really good first step.
Mr. Wormington, if you could just delay for a moment. We do have a vote on the floor, and Commissioner Nunn and I are going to have to leave, but I would ask, if your time permits, if you could chair the hearing and ask your further questions, and also hear from Mr. Wormington. But I'd like to yield so that we could get over and vote. Thank you so much.
All right, thank you, Mr. Chairman, for holding both this important hearing today, and we'll make sure that we move expeditiously here. But we want to talk about examining the lies and the duplicity of what the Chinese Communist Party has done, particularly when it comes to audits. China is not new to the realm of misinformation and deceptive practices. In fact, just a couple of months ago, this very commission reviewed the CCP's lies when it came to the inaccuracies in the Universal Periodic Review. Today, we're going to examine the CCP's abuse of third-party social audits to hide their use of forced slave labor in products used by everyday Americans, perhaps even many of us in this room. The truth is that China will stop at nothing to deceive the West and skirt our enforcement mechanisms as the administration has attempted to apply. The CCP continues the abuse of Uyghurs and other religious factions and illustrates that they will continue to commit genocide and crimes against humanity in order to fulfill the CCP's interest and that the exploit for distinct market advantage even against us here in the West. However, the CCP does not act alone, and this is one of the things I want to focus in on today. As we will discuss, there are certain corporations and third-party actors have no issue in assisting the CCP in their maligned activities. In fact, I would offer the weaponization of social compliance audits indicates the CCP has strategically stacked the cards in their favor when it comes to uncovering forced and slave labor in their country. So, Mr. Chairman, I want to applaud you for taking on what is both a difficult issue, but one that has challenges both inside China and outside China. And I want to thank the witnesses for taking time to share your expertise with us today, as well as the Senate and the administration for being involved in this. So I'd like to begin with you, Mr. Wormington. You talked a lot about, the mining companies, the different aspects of this. Let's just ask the big question in the room. Are Western companies being compliant with the CCP and helping them hide their abuse of the use of Uyghur and other slave labor forces? And I ask that we top level.
Yeah, I think what's really clear, for example, from our research on Volkswagen, is that companies do have standards that they are applying outside China that they are not applying inside of China.
Do you think the CCP is playing a direct role in influencing these companies, either overtly or covertly?
I think it's certainly true when you talk to car company executives, that the fear of reprisals that they face from the Chinese government is affecting how they're interacting with their own suppliers and their own staff in China.
Do we have blind spots when it comes to this? We certainly have it in the auditing side, but we hear the anecdotal evidence coming from companies. I'd like to know, where are we most out of information, or where are those gaps existing?
Yeah, I mean, so the Uyghur Forced Labor Prevention Act is an extremely effective piece of legislation in stopping products from coming into the US where they are linked to the Uyghur region, to Xinjiang. The question is, and this is the blind spot, what are the products that come from the Uyghur region? Because companies, like car companies, have thousands of suppliers, thousands of sub-suppliers, and at the moment they do not know whether or not some or many of those sub-suppliers are in fact sourcing from the Uyghur region.
So aside from the obvious monetary profit that these companies are getting, are there other items behind why they would be standing with the CCP, rather than their perceived Western values of a free and independent labor force, when they know at some point in their supply chain they are exploiting a group of individuals for their own corporate profit? Are there other rationales why anyone would be doing this?
And the reason, again, to take the example of the car industry, is that many of these companies have huge business in China, have huge financial interests in China, have huge joint ventures in China. And the decisions that they're taking are, of course, partly motivated by threats and reprisals from the government, and partly motivated by the fact that they have big business in China.
So by deterring this or calling it out, they would effectively be stepping away from China as a source of production for themselves.
Well, we've seen the risk, for example, with H&M, that where companies come out and say they're not going to source from the Uyghur region, they face reprisals both online in China and in terms of their market share.
I'm going to now ask Mr. Nova, you've done a lot on the social auditing side. How effectively do you believe social audits are on both uncovering as well as addressing the labor rights abuses that are coming out of the Uyghur region within China?
I think social auditing is an ineffective mechanism under the best of circumstances, and the situation in China represents the worst of circumstances in terms of the challenges and obstacles to auditing. So I do not believe reliable information is being developed. And indeed, I don't even think corporations are fully utilizing the options available to them to at least try to do it a little bit better. And just to speak quickly to your earlier question, I don't think there needs to be another motivation besides money. Corporations aren't in the business of values, they're in the business of profit for shareholders. And if making that profit requires bending their practices in such a way that it's acceptable to a host government, in this case, the most important host government, the Chinese, historically, they've been very happy to do that.
Well, Scott, I agree with you on aspects of that. I will hopefully highlight that we as consumers do have values, and that a lot of what drives our decision-making is based on the fact that we don't exploit labor, that we don't use slave workforces in order to do it. We fought an entire civil war here in this country for this very purpose. And I would highlight, I think that you nailed it on the head here, we want to have visibility and transparency into this so that we as consumers can make informed choices and do hold those corporate entities, whether they're in China or here in the United States or elsewhere, accountable. So I guess my next question then is, who else besides just the government, which I think is performing admirably here, can help to hold these institutions accountable, particularly the multinational entities?
Well, there are, of course, other country governments, which also need to step up, and there's been some positive movement in Europe in this regard, I think following the lead of the United States government in terms of addressing this specific issue, so that's encouraging. You make a very important point about consumers, and there are consumer organizations, but consumers aren't a highly organized, highly mobilized constituency. If they were, I think we'd have very different supply chains, because you're absolutely right. Consumers don't want to be wearing clothing made with forced labor. They don't want the solar panels they're proud of installing on their roof to include polysilicon that was made with forced labor. And if consumers understood fully what was happening in supply chains globally. They would demand change. The primary function of social auditing is to shield the actual practices in the supply chains from the scrutiny of consumers, and thereby enable business as usual to continue even in the absence of a level of humaneness that consumers would consider minimally acceptable as consumers. And so we need to remove that shield and ensure that consumers can see what's actually happening. And if we succeed in that regard, then we will see change, because at the end of the day, corporations need someone to sell their products to.
Mr. Nova would not disagree with anything you just said. I think that's on mark. Let me ask then, are there success stories that we can point to for a further replication that really highlight how do we provide the transparency, both to the consumers, both to the end user, as well as to the corporations themselves that are trying to acquire this, to know what is actually happening in China so that we can hold these folks accountable?
There are examples from other countries that are positive. I talked earlier in my testimony about the horrible situation in Bangladesh of workers dying in fires and structural collapses in buildings that had supposedly been inspected, factory buildings, by auditing firms. But after the worst of those disasters ultimately created enough pressure that more than 200 brands and retailers signed an enforceable agreement with worker representatives, not just to do inspections, but to clean up the buildings, to renovate the buildings and help pay for it, to make them safe. We then saw a radical physical transformation of the production infrastructure of the Bangladesh garment industry, resulting in concretely, demonstrably safer factories for more than 2.5 million garment workers. And a key component of that was that the results of the inspections done by the safety engineers, each hazard identified and the remedy necessary to correct it, was published, and the progress of each factory toward correcting each of those hazards was reported publicly on an ongoing basis. That is the opposite of what happens in the field of corporate social auditing, where nothing is public. The workers themselves don't see the results of the investigations that supposedly exist to protect their rights. But can you have in China an agreement like that? You spoke to this earlier, Secretary Li. Who signs an agreement on behalf of workers with corporations that speaks to what happens to workers in China? That's the challenge with replicating that model in the Chinese context.
I mean, I think we can speak to, millions of car owners here in the United States that potentially are going to have electric vehicles placed on them, or even want to do it for their own energy efficiency or social consciousness, don't want to know that that battery came from a cobalt mine that was done by a child labor force perpetrated by the Chinese on a country in Africa. I think that there's real requirement here for us not to do the facade of social auditing, but to have true transparency here. Thank you for your testimony. Deputy Undersecretary Li, you've been a leader in this with the administration. Some of the recommendations that have been provided here, I wonder if you might share with us a little bit, if this transparency were to be provided, if we were able to have a better indication for not only Americans, but consumers around the world, what roles can the administration do in enforcing this, hold China accountable, and ultimately make sure that we as the consumer have some kind of an insight into what's happening here so we can make our own market-driven choices?
Thank you so much, Mr. Nunn, for that question. I mean, I think transparent, accountable supply chains are essential, and it's something that in some ways we got away from in the go-go days of the global economy, where these complex and fractured supply chains exist so that corporations do not have to take responsibility. They don't have to know. But I think it's completely possible. It's just that we have to change the business culture to make it understandable, that everybody from the CEO on down in a company understands that, obviously they're making purchasing decisions that require, you decide where you're going to buy it from, what's the quality of it. There's quality control, there's price, there's everything else. You could, if you wanted to, know who the people were. So I think that we are working in that direction in the U.S. government in terms of both what's required by the Customs and Border Protection and enforcement of things, but also in terms of the international finance loans, in solar supply chains, looking for more transparency at every stage of the supply chain. So that is something that we are very committed to doing, and I think it's all good. It's good for consumers. Ultimately, it's good for businesses. They may resist it in the short term, but I think this is the way of the future, and I think we have a situation which is morally unacceptable if we don't have that transparency. Thank you, sir.
Thank you, Deputy Undersecretary Li. Thank you, Chairman. And I would highlight, let's hold the bad actors accountable. let's recognize the many who have tried to step out on this front to do the right thing, both as consumers and as corporate citizens, and ultimately recognize that the real threat here is coming from a government that has largely enforced a slave labor mentality on its own people inside the CCP, and the ultimate adversary here are the people who are allowing this to happen at the front end. But the threat happens both inside and outside of China. Thank you, Mr. Chairman.
Thank you very much. Again, I'm sorry, we do have to leave. It's on zero over at the, on the floor. And I really thank our distinguished commissioner for taking over the hearing. Without objection, a statement by Alicia Hennig will be made a part of the record. And again, I thank you so much for your recommendations and your testimony.
Thank you, Chairman Smith. I think we'll resume where we left off with Mr. Wormington.
Thank you, Commissioner. Yeah, the question of recommendations for FLETF, I think, is a really important question. I have one very simple one up front, which is that aluminium be made a high priority sector because of the percentage of the material globally that is coming out of the Uyghur region. I think that should happen as soon as possible and certainly by this summer. I think then in terms of the broader recommendations, this question of supply chain transparency would really be front and center for me. As we've said, the Uyghur Forced Labor Prevention Act is an extremely powerful tool. And the question is, how do we identify those products that are coming from the Uyghur region into the US? So far, that identification has been done sector by sector based on the priorities for enforcement of CBP. And so, for example, in the automotive sector, I think that there's been a sense that electric vehicle batteries might be a priority for enforcement. And I know that that has then led to much more scrutiny on the supply chains of electric vehicle batteries within car companies. So as you have a priority, as you have a sense that enforcement is coming, you have reactions from the industry, which of course is exactly what we want. But we need something that creates those incentives on a much more systematic and systemic level, given how many products and how many commodities are linked to the Uyghur region. At the moment, CBP is using some techniques, for example, through questionnaires that they're giving to sectors, whether it's to solar, whether it's to textiles, about high-risk commodities like polysilicon or like cotton. And those questionnaires are designed to ask importers about the origin of their materials and about their supply chain transparency. But they are being done as part of that enforcement infrastructure and not as part of a systemic legislative effort to push for more supply chain transparency. So I think it's really important we look to other models. For example, Dodd-Frank, that has been used for conflict minerals to generate transparency over supply chains at the refining of high-risk metals from the Democratic Republic of Congo. And we should think about, if not necessarily transposing that exact same model, then what is the model for using legislation to drive transparency across high-risk commodities linked to the Uyghur region?
Thank you very much, Mr. Wormington, for that answer. And I think we're ready really to wrap up, but I wanted to give each of the witnesses a chance if there's any last point that you wanted to make before we adjourn. Mr. Zenz? Dr. Zenz?
Sure. We've, I think, had very important input, very educated input, and in my opinion, this is such a long-standing problem in so many ways. We have seen so many gaps also in understanding the nature of state-imposed forced labor and the kind of challenge that this poses. The ILO itself discounted the role of state-imposed forced labor. It discounted this role in the 2000s, said that we needed to pay more attention to modern slavery, to global supply chains, which of course in many ways was very true, but it also kind of disempowered multilateral institutions and the ILO itself to be less prepared, firstly to kind of stumble through the Uzbekistan situation in a way that was heavily criticized, but then also to be quite unprepared when the Uyghur situation really exploded and is now the largest system of state-imposed forced labor. And so I would really urge Congress and the administration to follow up, to hold these hearings, to commission this report into the status of auditing in China, as suggested. For the UFLPA guidance to update its requirements of supply chain disclosure up to the raw material level for high-risk sectors and so on. To hold hearings and to investigate the practices. Under what circumstances did MSCI remove this rating, which is unbelievable. And so I think it's so important to have these. In many ways, when I was preparing for this hearing, I felt this is kind of the tip of an iceberg, and it's like It's like the opening of a door that leads to a whole building. And so I just want to emphasize with this metaphor the need for follow-up hearings and follow-up action on several of these issues. Thank you.
I just reiterate what I said earlier about the importance and value of intensified scrutiny of the methodologies being employed by corporations and the auditors that they utilize to ostensibly ensure compliance with the UFLPA and with Section 307, and whatever can be done to draw out information and create transparency about what companies are and are not doing, I think would be extraordinarily helpful in advancing this debate and enforcement of those laws.
Thank you so much to all three of you. Your testimony has been extraordinarily useful and valuable, but also the work that you all do all day, every day is valuable to us, and so we appreciate it. We look forward to holding the next hearing, which will, I think, delve deeper, as you say, Dr. Zenz, into the door that's been cracked open a slight bit. But I think you all have raised a lot of systemic issues here that are not going to be solved in the short term or not solved easily. But I think you've also put before us some very concrete and valuable suggestions for how we might proceed. So I thank you for your time. I thank everyone for being here. And with that, I conclude this hearing.